It's early in the morning. I'm preparing for yet another foreclosure trial, and I want to talk about the double standard that exists in courts in the context of foreclosure cases versus all other cases in the civil justice system. Now, it'll come as a surprise to many to understand that there's only one rules of civil procedure. There's only one rules of evidence, and those rules are supposed to apply against all cases that exist in the civil court system. But we know from experience that there are differing standards that are being applied in foreclosure cases. Foreclosure defendants are quite frequently treated as second-class citizens that don't have the same rights as all others that appear in front of a court system. The justification being that, well, you haven't paid your mortgage, and so the bank doesn't need to fulfill their obligations under the rules of civil procedure and under the rules of evidence. And where this burden is demonstrated very frequently is in books and records, and quite frankly, that fundamental allegation of default. Can the bank prove that a homeowner is in default under the rules of evidence that it currently exists? And quite frankly, in many cases, they do not, because with the multiple changes in servicers and multiple changes between law firms and everything else, the firsthand information that's necessary just doesn't exist, or it does exist, but because of the business models that have been adopted by the banks and their servicers, they choose not to spend the money to respect the rules of evidence and civil procedure that exist across all of civil litigation. And unfortunately, our courts are letting them get away with that. Now, there's one example that I think is really dramatic, and it's one of the most consistent ones we see over and over again, and that is plaintiffs come into courtrooms with Xerox copies of documents, and they wave them around and they say, Judge, we want you to admit these books and records, or we want you to admit this pooling and servicing agreement as evidence of a fundamental fact that we need in order to prove their case. Judge, the rules of civil procedure do not permit parties to come into court with copies of documents, wave them around, and establish those as evidence. There are reasons why the rules of civil procedure require authentication of documents and require that the proponent of the evidence be able to speak with credibility about those documents. So, frequently we have these pooling and servicing agreements come in. A plaintiff is a Deutsche Bank trust or some other trust, and the plaintiff marches into court, waves around, and asks the judge to grant that alphabet soup plaintiff some trust that no one's ever heard of, $250,000 judgment or $500,000 judgment, and throw that consumer out into the street. The problem I have, and the problem that judges should have, and frankly all of us should have, is that the plaintiffs frequently fail to prove up through admissible evidence that trust even exists. I'm holding in my hands what is a admissible true copy of a pooling and servicing agreement. This is the way that a plaintiff proves up that in fact a trust exists, through an admissible document. Now, I'm going to tell you something. I've done many, many trials. I've been in this for a very long time. I have yet to see in any case a plaintiff come into court with what this is, and this is an original document, an admissible document that proves that a trust exists. Now, there's a very simple objection when they come in with the copy of the pooling and servicing agreement. It's best evidence. It's authentication. And it's a black and white issue from appellate perspective. In any other civil litigation, if a party would come into court with a photocopy of a document and ask to have it admitted, and the defendant timely makes an objection to that document, there is no question but that the judge would absolutely say, I'm sorry, proponent of that evidence, you haven't met your burden. You haven't fulfilled your basic obligations to comply with the rules of evidence, the trial objections that exist, and the rules of practice and procedure. And yet what we find frequently in foreclosure cases is a judge will look at the defendant advocate doing their job that you've taken an oath to do, and trying to force the plaintiffs to comply with some basic rules of procedure. What you'll frequently find is a judge saying, I'm going to overrule that objection. Your client hasn't paid the mortgage, even though the plaintiff hasn't even proven that fact. But somehow, because we're a defendant in a case, we're not entitled to the same protections and the rules of civil procedure that exist across all civil litigation. Now, I want to show you, this is just a sampling of the preparation that goes into a trial. You'll note that there are folders here, one right after the other, that come with cases on each of the relevant points that exist. You don't just walk into court in any trial and say, objection, judge, I don't think that document should come in. Each objection has to be very clear, has to be very specific, and has to be supported by the law and the cases that are the foundation of those objections. So, as much as I have criticism of plaintiffs, likewise, defense advocates are guilty of the very same thing. You don't just get to come into court and object to a plaintiff's case without having done your work, your homework, and put in long, long hours in order to properly present and prepare the objections. I recently had an opportunity to go down to a seminar in a meeting with Evan Rosen. He's a trial attorney down in South Florida, and I got to tell you, he is a master of the rules of civil procedure and a master of the rules of evidence. One of the interesting things is Evan comes to the foreclosure fight, the defense of foreclosures, with a very, very successful background in insurance defense and all other litigation. And so you get an experienced litigator like Evan who would prepare for trial, no matter whether it's $1 million slip and fall case or frankly, a small claims case. Preparing for trial, hours and hours, weeks and weeks, and go to trial. He uses that same preparation in going to a foreclosure trial. And why shouldn't you? In fact, that's the absolute requirement. When we're practicing in court, it's the exact same rules. So you have to know the rules, which brings us to the point. Unfortunately, consumers are oftentimes critical of the court system because they feel like they're being railroaded or not being treated fairly when they walk into a courtroom and lose because the rules are being used against them. And unfortunately, in this environment, we have to be held to the same standard. The defense side of the equation must be held to the very same standard that we're asking the plaintiff side to be held to. It's only fair. And so if you're going to go into a foreclosure trial, you need to be very careful to not get distracted by issues that are not relevant. And quite frankly, if you're a pro se litigant walking into a courtroom, or if you're an attorney walking into a courtroom that doesn't have significant trial experience, and particularly significant trial experience focused in foreclosure cases, knowing exactly what those current cases are, in all likelihood, you're going to lose. And quite frankly, you probably should lose because we cannot allow the defense side of the equation to fall into the sloppiness, the unpreparedness, and the failure to properly present a case that the plaintiffs are getting away with. With proper preparation and a stack full of cases, you should have great confidence walking into a courtroom knowing that the judge is going to follow the law, is going to follow the rules. But quite frankly, they're not going to do it without a fight. You got to be prepared to go in there, well prepared, far in advance, with each of the elements that are necessary to defeat their case. Otherwise, you're going to lose. That's the environment we practice in. That's what we should be doing right now, properly preparing for foreclosure cases if you expect to be prepared and win.